Good morning. Today I want to talk about a scenario that we're finding much more prevalent than it's ever been before. Getting your green card has never been harder. It takes longer. There is more pitfalls. There's a lot more roadblocks to you getting your green card today than there ever was before.
Calificas para ser legal, quieres saber, solo llama al abogado Andrés Mejer.
Now, there's a number of ways to get your green card, and in this radio program in Spanish, we've discussed it a number of different ways. A family-based petition, an employment-based petition, victim of violent crime or trafficking, so a U visa, an S visa, VAWA, Violence Against Women's Act, Special Immigrant Juvenile, asylum, cancellation of removal for those that don't have a green card. So, and a host of other employment-related type visas, sports, authors, exceptional individuals. There's many ways to get your green card. But once you have it, you have it. Now, historically, once you have it, you tend to keep it. And there are people that never become U.S. citizens that just stay as a green card holder. It is something I strongly encourage you not to do. If you have your green card, look for a way to get your citizenship as quickly as possible, because under this administration, they don't want you to keep your green card. They don't want to keep you as a green card holder. All immigrants are a problem and all should be deported. That's the mentality that we're seeing. That's the approach that we're seeing. So if you have a means to become a U.S. citizen, do so. I'm going to talk to you now about 3 different scenarios about how the government is trying to deport them. So let's just get right to it. The first one is Jose Luis Garcia. He was picked up a couple months ago, one of 15 that were arrested in a 3-day ICE raid in California on public safety threats. Jose Luis Garcia was 62 years old. He's a grandfather who left Mexico when he was 13, so almost 50 years ago. Married, U.S. citizen wife, U.S. citizen kids, U.S. citizen grandkids. I believe he's now retired. He was arrested in 2001 for domestic violence. Now, it's unclear whether he was convicted or not. I'm assuming that he was. 17 years ago. Because of that conviction, he's now picked up and awaiting his trial date. Second example, Lucas Nich. He came to the U.S. when he was 5 years old from Poland. His scenario is very similar to mine, except I'm not Polish, meaning I wasn't born in Poland. I was born in Santiago, Chile. His parents were both doctors. He became a lawful permanent resident in 1989, grew up in Michigan, went to high school here, went to college, went to medical school, is a medical doctor. He likely received his green card under President Reagan's amnesty. January 1992, he was convicted of malicious destruction of property valued under $100. There was a car accident. There were a number of people in the car. He got out. There was a fight. He was charged. He was underage and he was a juvenile. And this was 3 years after he got his green card. 1992, he was convicted of receiving stolen property valued at over $100. Again, he was a minor. In immigration perspective, he was under 21, but I think he was even under 18 at the time. And the charge was expunged. And teachable moment, big deal. If you're an immigrant, there's no such thing as an expungement. Don't ever expunge something if you're not a U.S. citizen. It will not help you. There is no such thing as an expungement for immigration purposes. What happens is you make your attorney's life miserable because now we can't get police report, we can't get a disposition. If you don't have that information before you got the expungement, you can't get it now. 2013, he was arrested for domestic violence. He did the smart thing. He fought it. He got an attorney. He went to trial. He won at trial. He was not convicted of domestic violence. So we got 2 1992 juvenile violations and a DUI. He's a doctor, and yet, he was detained in his home after his kids went off to school. Third situation, Dane Foster, Jamaican, lawful permanent resident. He was picked up. He was one of the 105 immigrants that were picked up in New Jersey by ICE the week after our Attorney General said, you know what, we're not going to play nice with ICE anymore. He entered the U.S. as a lawful permanent resident in 1997. He's married to a U.S. citizen who's a disabled military veteran. She was deployed abroad. She was injured when a mine went off, or an IED, and she's disabled. Blew up her pelvis. She can't work, legally disabled. He was convicted of simple possession of marijuana in New Jersey. In New Jersey, it's a disorderly persons offense. It's not even considered a crime. It would maybe be a misdemeanor, but New Jersey does not have misdemeanors. No jail time. Didn't even do probation. And here's the weird part, because in New Jersey there's a program called conditional discharge. It's your one-time get out of jail free card. If you're charged with something like possession of marijuana, well, you don't plead guilty. You go in front of the judge. You get put in probation for 12 months. There's some counseling. There's drug tests. You pass it. A year later, probation ends and the case is dismissed. But the point of this is, why, if he was only arrested once, why didn't he apply for a conditional discharge? We don't know when this happened. Maybe he had the conditional discharge and then was charged a second time after the probationary period. So we don't have enough facts, but it's bizarre enough from what his wife says. No probation, no other arrests. I don't know if he had an attorney. It's bizarre. Now, 3 scenarios, 3 different parts of the country: West Coast, mid country, and then East Coast. Now, there are 2 different solutions that we could look at to help these individuals. One is called post-conviction relief. That's a scenario. Now, that's where you're applying to the judge that convicted you with trial, or you pled guilty. It's after the appeal time has lapsed, and you're saying, Your Honor, I was deprived a fundamental constitutional right, and I'll give you some examples of how we've done it in the past. But it typically should be filed within 5 years. It's much harder to do it after 5 years. We at Mejer Law define this in 3 different categories. First is we order the transcripts and the discovery and see, listen, was there a fundamental right that you were deprived? And if so, how can we argue? What's your chances of success? Once we find a path, we say, listen, there was definitely a problem here. We file the motion with the judge. We appear before the judge. We argue the motion. If the judge agrees and grants it, now the conviction is gone away. But we still have to defend you. So that's the third part. So now we have to defend. So let's say Dane Foster's situation. Let's say this was his first arrest, and maybe he was arrested on a Sunday and convicted on a Tuesday. No attorney, just paid the $200 fine or $500 fine. That was it. It's actually closer to $1,000 with Dieter, and it's almost $1,000 fine. But let's say that is what happened. Well, we file post-conviction relief. We say, listen, he had no counsel. He wasn't aware of his rights. We order the transcript. Transcript probably shows that the judge didn't inform him of his rights, just accepted his guilty plea. That sets it aside. Then he applies for conditional discharge. The moment he applies for conditional discharge, the crime has already gone away, because the moment the judge signs a post-conviction relief order, the conviction no longer exists. Now he's just defending the charge, and that charge alone is not a deportable offense, assuming he wins it. So most common reasons for post-conviction relief are ineffective assistance of counsel. My attorney didn't do X, Y, and Z, which any normal attorney would have done in this circumstances. Or the judge or the court didn't properly inform me of my rights. When I go in front of the judge and I plead guilty, now I'll be asked a series of questions. Usually it's done by my attorney. It might be done by the prosecutor. It might be done by the judge. But the judge has to inform me of certain rights. For example, that I'm entitled to evaluate my immigration consequences, that if I plead guilty, I may be deported. If I want to apply for citizenship in the future, I may be denied. Or if I leave the U.S., I may be refused admittance because of this conviction. So the judge will ask me, did I speak to immigration counsel? If I say no, the judge will ask me, well, do you want an opportunity to speak to one now? And if I say yes, the case will be adjourned. I will speak to an attorney, or I'll have the opportunity. If I come back and I don't do it, that's on me. So judge or court didn't properly inform me of my rights. 3, there wasn't a translator available, so my plea wasn't knowing or voluntary. Let's say Jose Luis, the first example, the 62-year-old grandfather. Let's say for purposes of conversation, he was arrested over the weekend. Maybe he had a little too much drink. maybe not. I don't know what the circumstances are. I just know that this is common associated with alcohol. Shows up in court on Monday or Tuesday, just pleads guilty. There wasn't a translator there. Let's say back then his English wasn't so good. Maybe that's why he never became a citizen, because he was concerned about his language, inability to pass the test. So there was no translator, didn't have an attorney. Even if the judge gave him the instructions, if without a translator he didn't understand what those instructions were, so his plea was not knowing and was not voluntary. That's a basis to set aside the conviction. Last one's a little newer. Defense counsel didn't properly advise you of the immigration consequences to a plea or conviction. Even if the judge says it, even if the prosecutor says it, if your attorney tells you, says, listen, that's a formality, don't worry about it, that's nonsense, you're screwed. Just plead guilty and everything will get better, and you'll be released and life will be good. That, the attorney could have given you bad advice, and you relied on that advice. It was incorrect advice, and because of that, you never would have entered into that plea voluntarily, but for the bad advice the attorney gave you. By the way, bad advice that most other attorneys would not also give you. The standard of care is, what does your average attorney do, not what does the best attorney in the country do. Best attorney in the country is not the standard by which you're judged by when they're looking at this. So those are the most common circumstances in which we file and receive a post-conviction relief motion. So now let's look at Jose Luis. Again, I just gave you an example of how that could be done. We don't have much information. It was 17 years ago. Was domestic violence for his wife? Did his wife want to press charges? Did he go to counseling? In New Jersey, if this happened in New Jersey, again, quite often these convictions happen really quickly. No time to speak to an attorney, no translator. So let's say here there was a dispute. Maybe he had too much to drink. Someone called the police. We don't know if it's a neighbor or the wife or him. Someone calls the police. Maybe he fell, but he was walking. He was inebriated, tripped over something, fell on top of her or near her, knocking her down. She falls, has a mark on her face. Police comes in, charges him with domestic violence. Now, maybe it was an accident. Maybe it wasn't. I don't know. Again, I'm giving a scenario that I've seen too many times. She says she doesn't want to place charges. She says she's not afraid of him, but the police sees a mark, so they charge. They arrest him and they charge him. He goes to court and he says, "What happened?" "Well, I fell on her. She was injured." "Was she injured?" "Yes." "Okay, I'm sorry, I pled guilty." Pays the fine and leaves. Here we are 17 years ago. Now there's consequences to that plea. We have to relook at it. Maybe we can reopen it. Maybe it wasn't appropriate. We have to see what the circumstances were. I'm giving you one scenario where, look, at the end of the day, one charge for domestic violence should not be a basis to deport somebody, particularly someone who's been here 50 years, and that's the only arrest he's ever had. So he's clearly been rehabilitated, even if he made a mistake, and that is not a 100% deportable offense. So that standing alone by itself, post-conviction relief motion is one avenue. He should be eligible for a bond in front of an immigration judge. It'll be high in this climate, but he's eligible to request it, and he likely will have it. So he'll post bail, and then he'll have his trial date in 2 or 3 years, and we'll talk about the defense. Now, if the post-conviction relief motion is successful, if we turn aside that plea, Jose, then his deportation proceedings are over. No conviction, he's not deportable. Let's talk about Lucas. So Lucas, 1992, juvenile offense, before the 1997 law change. These aren't really considered crimes. He was a juvenile, he was a minor, even when it happened. Now granted, it was within 3 years of him becoming a green card holder. That could very well be a problem. So we will evaluate what those options are. Look, 1992, the problem is there may not be a transcript nowadays. There may not be a police report. And frequently in juvenile scenarios, it's not worked up in the same way as an adult offense. The onus is on us now because the government is saying we're deportable, and we have to try to reopen it. We have to try to apply for a bond. We have to figure out, well, what can we do in Lucas's situation? He is bond eligible because I'm going to take the position that those two incidences are not a crime of moral turpitude. They're not even crimes because he was a minor. Now, you have to look at what the case law is. He's in Michigan. Michigan is a different judicial federal circuit than in New Jersey. New Jersey, we're under the Third Circuit. So I have to see what is the crime, how has it been interpreted by the federal courts in his area to make that argument. In New Jersey, I can make that argument and I would likely win. Now, DUI, that's a big one. That's a problem, but he's not going to get deported because of a DUI. The domestic violence, he won it. It was dismissed. He was found not guilty at trial. So what are we really looking at? It is really a 2008 DUI, more than 10 years ago, clearly rehabilitated. If the 92 violations are a crime moral turpitude, again, I'm arguing it's not a crime because he was a minor. If I win that argument, he gets bond, and then we prepare his defense. Now, if we're successful with the post-conviction relief motion, either in DUI or on those 1992 convictions, then he's not deportable anymore. Which is why I like the post-conviction relief motion so much, because if you're successful, case is over. Then you don't need to worry about a trial in front of an immigration judge where it's unfortunate to say, but the outcome is arbitrary. For the simple reason is, what judge you're in front of makes a tremendous amount of difference. If you're in the Atlanta region or in Georgia, you're screwed. It almost doesn't matter what judge you're going to get, you're not getting a fair shake. It's just the reality of the circumstances. When you look at the denial rates in that jurisdiction are massive. Almost everybody gets denied, even with a good case. It's unfortunate. It really shouldn't be that subjective. A judge sitting in California versus a judge sitting in Florida, Texas, or New Jersey, the outcomes should not be that much. It should be about the law. It shouldn't be about the opinion of the judge, political or otherwise. That's my opinion. I'll get off my soapbox. But Lucas, 1992, I'll likely argue that's not a crime moral turpitude. I will get him bond. It'll be high because of his 2008 DUI. He's probably looking at 7,500, 10,000, 12, between 7,500 to 12,500, depending on the judge. Dane Foster, that's a bigger problem. He's not bond eligible with a conviction for possession of marijuana. Now, I might ask for the governor to give him a bond. I might look at a pardon, Governor Murphy. I might look at I'll look at post-conviction relief motion. I'll see what happened, what was the arrest, what was the conviction for. We've been successful where there are two people in the car. None of them have attorneys. The marijuana is in the car. They both get charged and they both plead guilty to possession when the reality is it was only one person's, not both. So we've been able to make that go away. Also, if he was only arrested once, why didn't he apply? Why wasn't he accepted to the conditional discharge program? I would file a post-conviction relief motion, probably argue ineffective assistance of counsel, apply for the conditional discharge. Once that's resolved, he can get a bond. So he has avenues for relief, but he's not going to be bond eligible with that conviction. So if it's pardoned, it's pardoned. Now, we do have to see, again, what happened. Can we reopen it? So let's talk about the other defense strategy. It's called cancellation of removal for those that have a green card. Now, there's cancellation removal for those that are non-green card holders. In Spanish, in slang, they call it the law, the ley de 10 años, the 10-year law. There is no real 10-year law, but it's a defense to deportation. There are more than two, but there are two principal distinctions. One is if you have a green card holder, it's easier to apply and receive it. If you don't have a green card, you got to show you're here longer, and the hardships are higher. All three of these individuals can apply for this defense. 4 requirements. Must be a green card holder at least 5 years. That's a no-brainer for any of them. They've almost all of them had it for 20, or in some cases 40 or almost 50 years. 2, lived in the U.S. for at least 7 years with some kind of legal status. They both got that. 3, not convicted of an aggravated felony. No, none of these were convicted of an aggravated felony, although possession is close, but possession is not an aggravated felony. However, possession with intent to distribute, that's drug trafficking, and that is an aggravated felony. Aggravated felony doesn't have to be aggravated or even a felony. It's definition by statute. And when did that come into play? Before 1997, but after 1997, immensely expanded the crimes that are now considered by immigration as an aggravated felony. Last criteria is really, do they deserve discretion in this case? Put another way, how will deportation affect their family, who are U.S. citizens or green card holders, in the event of deportation? Well, let's look at Jose Luis. Yeah, I mean, 5 years, so he's been in the U.S. almost 50 years. Been a green card holder, we don't know how long, but a long damn time. This should be an easy case to prove. He has a wife he has kids, he has grandkids. So been here a long time, only one arrest. You know, good moral character shouldn't be hard to prove. Really, hardships here, we don't have the details, but there's more than enough information to present to work up an appropriate cancellation of removal case. Lucas Nietzsche. Also, easy case to prove for cancellation of removal. Been in the U.S. 40 years. He's a doctor of internal medicine, good reputation, U.S. citizen wife, 2 kids who would be harmed if he's deported. You know, his offenses are 2 as juvenile and 1 a DUI. He's not going to get deported for just a DUI. When you look at the factors and you look at who he is and the impact that he does and the good things that he does in his community, those far outweigh a DUI done 10 years ago. So rehabilitation, huge here. No repeat. He's not a repeat offender. So and let's not forget, he was licensed by a medical board. That is hard to do with criminal conduct. So not a bad guy on paper, easy case to make for cancellation of removal. Dane Foster, well, I mean, his wife is a disabled military veteran. They have 4 U.S. kids. He's the sole breadwinner for the family. Again, hardships are massive here, not hard to prove. And if we make the simple possession charge go away, well, so does his removal. So I typically go about this, I look at the post-conviction relief motion first, for the simple reason is, if they're detained and they're not bond eligible, if I get the matter reopened, they now become bond eligible to get out of detention. 2, if I'm successful and I change the outcome, they're also no longer deportable. So that may, depending on the circumstances, be a cheaper remedy, maybe a faster remedy to get them out of detention and also to stay in the country. Now, but that's because I do criminal and I do immigration. Not a lot of immigration do that. So most immigration attorneys will likely go for the cancellation of removal. That's what they're more comfortable with. They know that in each of these cases they can prove these scenarios, and they'll be successful. But the problem is, in some of these, they're going to be detained for 3, 4, 5, 6, 7 months. And that's unfortunate, when perhaps with a post-conviction relief motion, we can get them out after 2 or 3 months. Please share this video if it was helpful. Thank you for your time. This is Andres Mejer signing off.